welcome to the Hodder. I'm Sasha Hodder, and this week we're going to zoom in on the Coinbase lawsuit, or the Coinbase-funded lawsuit against the Office of Foreign Asset Controls and Janet Yellen. Please make sure you subscribe to the page. More people can see this video and you don't miss out on any new content. Thank you. Coinbase filed a complaint against OFAC due to the Tornado Cash sanctions. Tornado Cash, they called it a purported entity. They sanctioned the Tornado Cash website, 37 different smart contract addresses, and an address that was used to accept donations for the project. So the sanction happened on August 8th, and the reasoning behind it was that the mixer was purported to have been used to launder funds. The lawsuit challenges the addition of Tornado Cash to the SDN list because it says it's an unprecedented, overbroad action that exceeded OFAC's statutory authority, and it infringes on their constitutional rights of the law-abiding citizens to engage in free and private financial activities. Got to give credit where credit's due. Although the lawsuit, I'm sure, helps Coinbase. They're involved in the industry. They want more people to use crypto. And if these type of sanctions are allowed to continue, could be a huge slippery slope for the whole crypto industry. So they certainly have a vested interest in seeing that OFAC not overstep their powers and infringe upon running code and criminalize it. But it's really good for the overall industry that they've stepped up and done this. It's, one of the best moves we've ever seen at a Coinbase. So really grateful that they're doing this. And the sanction, it could lead to a slippery slope. So the best time to stop something like that is just at the beginning. If it was let to go on, then the next time when you try and challenge it, it'd say, well, we've already been doing it for X number of years. Why do you think now we can't do this? So it's got to be challenged right away. The Tornado Cash code was developed by a number of people over a number of years. The plaintiffs are law-abiding citizens. The way I understand it anyway is that they're all Coinbase employees who have used the code in the past, and this code lets people deposit, withdraw, or send or receive funds through this Tornado Cash protocol. And the funds, you don't know if it has any connection to illicit activity, but certainly Americans that use it for the purpose of privacy or other completely legitimate reasons are now prohibited from doing so. When the president delegated sanction authority to the Office of Foreign Asset Controls, it was limited to activities involving property of a foreign country or a foreign national. Since Tornado Cash is a smart contract, it's immutable open source software. It's not property. It's not belonging to a foreign country, and it's not a national of a foreign country or even a person of any kind. This is an unprecedented type of sanction. And why did they go to Texas? Well, one of the plaintiffs is from Texas, but I think Texas, it's been known to be a pretty nice jurisdiction for crypto overall. So I think that might have had some play in it. But basically, one of the plaintiffs, Joseph Van Loon, was based in Texas. He's an application security engineer. He has an ETH-ENS name that's linked to his identity, and he used Tornado Cash to send money to a new, more private wallet in anticipation of running a validator node for Ethereum. And now he can't do that, so he's had to abandon his plan to run the validator node, and he's lost out on a potentially valuable business opportunity. Some other use cases, Tyler Alameda, a senior security risk analyst at Coinbase, he used Tornado Cash to donate relief funds to the Ukraine. So that's, I think, the perfect use case. Someone's trying to send money overseas to a war-torn country and wanting it to be private. The reason he said he wanted the transaction was private was that he was concerned that Russian hackers might target the wallet addresses that have donated to the public Ethereum donation address for Ukraine. Sure enough, the wallet that was the anonymized wallet, the Tornado Cash associated wallet, was spammed, so could be malicious spam. So there is a need for this, and they said, a few of the plaintiffs listed that there's no alternative on the market right now that can provide as safe of a mixing service. I think that's primarily because Tornado Cash is non-custodial. It's just smart contracts operating. Mr. Alameda has 0.3 Ethereum locked in Tornado Cash today, and one of the other plaintiffs, Nate Welch, he has 1.2 Ethereum that are trapped. So, this is a case where people's funds were just without any due process. They were just inaccessible now. President has authority under the International Emergency Economics Powers Act, the IEEPA, to declare a national emergency with respect to an unusual and extraordinary threat, which has its origin in whole or substantial part outside of the United States. On April 1st, 2015, former President Obama declared a national emergency against malicious cyber-enabled activities and authorized the Secretary of State to block property and interests in the property related to identified persons. When it's a person, there's a chance to appeal, but this case is different. Even in a similar case, Blender.io, where another mixing technology was sanctioned, that was considered a legal person. It's a custodial mixer, so it had like an omnibus wallet, kind of like Coinbase itself. Someone would send it to a custodial wallet. This individual or, group of people behind the project, they weren't registered as a company. They weren't registered with FinCEN, which is the requirement if you're going to be a custodial service offering services in America. You need that FinCEN registration. So they weren't following any of those regulations that they were required to follow. And even though they weren't registered as a company, it was a group of people behind the entity. Where Tornado Cash is different because it really truly is open source code. There's no people that can appeal this sanction. Without some kind of injunction, this designation will prevent the plaintiffs and others who are similarly situated from using the Tornado Cash protocol and from lawfully accessing their funds that were in pools at the time of the transaction. So there's a free speech argument in the complaint. I kind of wish they went a little more into it, to be honest. It's only a paragraph long. But it says, by providing a certain degree of privacy, Tornado Cash allows plaintiffs to engage in important, socially valuable speech. Now they can't make donations to support these important and controversial political and social causes. And OFAC has prohibited a substantial amount of protected speech relative to the plainly legitimate sweep of defendants' actions. I wish in this case that they went into that prior restraint argument that says, now it's a prior restraint on speech, which is the highest level of speech protection. But I think as this case goes on, that speech argument will get hammered out as it's heard through the courts. And then the due process constitutional argument, they said the plaintiffs with money trapped in the pool did not receive any prior notice before the deprivation of their property, and the denial of any pre-deprivation process whatsoever is unjustified by any national security interests, and the risk of erroneous deprivation of property is intolerably high under the Fifth Amendment. So you can't just take people's property without due process in this country, and that's exactly what they did here. So the prayer for relief, Coinbase is or the plaintiffs is asking the court to decide that to declare the designation null and void with no force or effect, that the designation was not in accordance with the law, it's contrary to constitutional rights, and it's in excess of the statutory jurisdiction and should be vacated and put aside. OFAC should be permanently enjoined from enforcing this designation. Plaintiffs should be awarded their costs in the litigation and any other relief the court deems just and proper. So about a week after this was filed, OFAC updated its FAQs, so they updated them on September 13th. That's 5 weeks after the designation was first put in place, which is, in my opinion, way too long. These FAQs should have gone up at the exact same time as the sanctions were implemented. But anyway, question 1076, OFAC said they designated the entity Tornado Cash for facilitating laundering proceeds of cyber criminals from North Korea state-sponsored hackers, and they were interacting with the source code itself. Basically, they said, for example, U.S. persons would not be prohibited from copying the open source code, but good luck finding that code now. The website's down, their GitHubs have been down. So they're saying that, I think this is because of the potential free speech challenge that they foresee. But they said, you can take the code and put it in a textbook. You can take the code and talk about it. You just can't use it. Well, that's not good enough. Number 1077, they said no U.S. person can transact with Tornado Cash. 1078, they said if you got dusted and received nominal amounts of funds from Tornado Cash, OFAC considers their sanction regulations to apply. The rules are just so broad from OFAC. No one can help if someone dusts them. Like if someone dusted me with some Tornado Cash associated transaction from Ethereum, I can't help that. I didn't ask for it. I didn't take any action to get that into my wallet. But now I would be forced, I've got to fill in a blocked property report and let OFAC know I have a quarter of a penny worth of Ethereum that I have to somehow figure out when I see it in my address, like do my own chain analysis and look and see, oh, this is Tornado Cash type of, it's been associated with one of those 37 addresses. So OFAC is saying they're not going to prioritize enforcement of people who have received dustings. It's still within their purview to do. It's still against the law to receive a dusting from an address, and you could be in trouble for it. They should have just come out and said, no, any amount. The problem is OFAC is strict liability, which means you don't have to have any intent. You don't have to know you're operating or transacting with someone who's on the foreign asset, the SDN list. That's, I think, where it differs from most other laws. Most other laws on the criminal side have some kind of intent or negligent or reckless component. Here it doesn't matter if you knew or not, doesn't matter how ridiculous it is, like if it's less than a penny or it's $10 billion, it's treated the exact same. In FinCEN, for example, usually there's certain dollar limits, like if it's under $2,000 you don't need to bother filing a suspicious activity report. OFAC, they don't have any minimums. The final FAQ they entered, they said if you sent funds to Tornado Cash but did not complete the mixing transaction before August 8th, you should apply for a license to OFAC to get your funds. To get the license, you need to disclose your wallet address, transaction hash, date, time, and amount. That kind of answers the due process question too. I think that they're going to use these FAQs as their defense and say, okay, it's not a free speech violation because you can still use the code for teaching or publish it in a textbook. So we haven't limited the speech of the code. There is a chance for you to get your funds back. So we haven't violated due process because all you need to do is apply for a license and tell us about your wallet and all the details of your transaction. And then we may consider giving you a license to get your money out of the pool. But I don't think those are sufficient resolutions here. And Tether has apparently just ignored the sanctions. Their defense is saying that they are not a US person and they don't operate in the US, so they don't feel that these OFAC sanctions apply to them. Circle, on the other hand, went the complete opposite direction and blocked all addresses associated with Tornado Cash. This type of action, it really has a chilling effect in the industry. For example, it seems that Chris Belcher, he's gone quiet. So he might be also nervous that making the join market protocol is not that different from this Tornado Cash protocol, and the operator of that got arrested. And these kind of privacy projects, they're really important for the future of Bitcoin. So it sucks that people are feeling uncomfortable to continue working on their development. I've been listening to this Unhashed podcast the last few weeks, and it's really good. One of the podcasters, Ruben Somson, he said he knows of a few other developers that have just kind of gone dark. It sucks because their corporate knowledge is gone, their pseudonyms are deleted, they're extremely talented individuals, and they have a lot of other opportunities. So working on Bitcoin projects, why risk potentially going to jail if you can be doing other stuff? Privacy is a really important part of the Bitcoin, for Bitcoin to work as we go into the future. What is the next 20 years going to look like? And if no one's brave enough to work on privacy because they could go to jail for it, which right now it's not illegal to be private in your financial transactions. Just think about cash. No one cares what people did with the cash before you got it, and you don't have any duty to look back and be like, oh, this cash was used for drugs. I think there was a study a few years ago that said almost all cash has traces of cocaine on it. So the difference with Bitcoin is that companies like Chainalysis and various banks and OFAC are saying if Bitcoin has been used for an illicit purpose in the past, it shouldn't be used anymore. The wallet should be canceled. It gets this low ranking on Chainalysis, and companies like Coinbase can't use it. That's why it's really important for fungibility that all Bitcoin should be treated the same. Who cares who used it before? If it's going to be like cash, no one needs to worry about that. We just don't know the full story here. It's possible that the developer, Alex Herstev, I hope I said that right, It could be that he was really working with terrorists or something, and that's why these steps have been taken. If we find that out, it would almost be a relief, because then the developers that are not working with terrorists, they might not feel as uncomfortable to continue their developments. But he's in jail. They can hold you in Amsterdam for 90 days without laying a charge. So he hasn't actually been charged yet, but he's been in jail. There's been people protesting outside the jail, saying writing code is not a crime, which it really shouldn't be. I hope he gets out of jail, and I really hope this lawsuit wins and that developers can keep building for the future. Thank you.